In continuation of the discussion regarding the general concept of intellectual property, I start with the patents, which are one of the prominent intellectual property rights and one of the oldest intellectual property which has been there, covered under industrial property. So patents are also considered as a tool for innovation. To what extent they are a tool, that is a question that to be examined. But all in all, patent has that very structure which may lead to innovation if the exercise of patents is properly regulated. So what is patent in the first place? So patent is a government document that confers an exclusive right to an inventor for an invention, and that invention may be of any kind, maybe product or a process that provides a new way of doing something or that offers a new technical solution to a problem. So meaning thereby, in a simplest term one can understand, patent is a government document that is issued in favor of an inventor to reward that very inventor with certain exclusive rights. And if that inventor has invented something which fulfills the statutory criteria which is being mentioned as novelty, non-obviousness and utility. So this very system is a very balanced system which on the one hand incentivizes the inventor, on the other hand it asks for the public disclosure that I will be coming next. So patent is a document which recognizes the efforts of the inventor by rewarding it and giving it a statutory expression, providing him or her exclusive rights to exploit his or her invention. So it provides legal protection to patent owners for their invention, and that exclusive period for which you can exploit your invention with the exclusivity, now it has been settled for 20 years after the adoption of the TRIPS agreement. So patents are, like other intellectual property rights, territorial in nature. So in order to make your invention patentable, you need to file an application for your invention in the respective jurisdiction where you wish to have the patents, and it could be enforced and protected in that very territory only. So they are territorial in nature, and the ultimate objective of providing patent is to promote scientific and technological progress and in turn give, you can say, dynamism to economic progress. So these exclusivities, how they work, how they promote the scientific and technological progress, that we will understand. So coming to the essentials of patents, what are the criteria over which an invention could be tested or the patentable subject matter could be tested? So first of all, you need to establish that what you are claiming is not a discovery but an invention. So what is that distinction? Anything which occurs in nature, may it be living thing, may it be non-living thing. If it is occurring in the nature and it is a product of nature in that sense, then it is a discovery. What you are doing, if you are just exploring that phenomenon or you are exploring that very thing, that thing will be considered discovery unless and until you transform it in certain other form. So discovery is a kind of exploration by the explorer, finding what is already existing, and there is no contribution of his own regarding that very either product or process. So that is discovery. For example, E equal to mc square, the famous equation of Einstein that has been observed, which was already in nature. The correlation was explored by Einstein, and that comes under the purview of discovery only. It is not an invention. Newton's law of gravitation. It is again, observing the phenomenon through which the apple on his head, fell on his head. So it means to say that these very phenomena or processes were not the contribution of Newton himself, but a kind of observation, exploration, which established that very correlation. So that is discovery. So what makes discovery an invention is human intervention. So by human intervention, if you put certain effort and transform that very thing into some other thing which is usable and which conforms all other criteria of patent, then that will be considered patentable, and that very process or product which has been converted through human intervention may be called invention. So first thing one has to establish it, what he is claiming or she is claiming is invention and not discovery. The second filter which comes is patentable subject matter. So what is patentable subject matter? Whether all inventions are patentable, whether that very objective criteria is always working, or you need to look into the respective law to find out what is patentable subject matter. So here, there are twofold, you can say, aspects or twofold approaches which are governing the patentability of a subject matter. Number one is an objective criteria where majority of countries consider invention as a patentable subject matter, not discoveries. And even certain inventions, if they pass all the criteria, because of certain public policy, they are excluded from the patentability list. So there are certain countries which exclude various inventions on the basis of public policy. For example, in India, if you go through section 3, it clearly enlists what is not an invention, and here you may see agricultural methods, surgical methods are not patentable subject matter, and the reason is the public policy, because being an agro-based economy, any method which is agricultural method may be needed to various stakeholders as farmers, and that is to be given free. The accessibility should be given, widely. Likewise, any physician, surgeon may need some surgical procedures, so that must not be monopolized or enclosed, and that would be, impairing the interest of all these physicians, and it may go against the very, treatment process. So that is why there are certain subject matters which otherwise pass the test of invention, but still they are being excluded from the patentability. Section 4 also talks about inventions relating to atomic energy. They are also being excluded for the security purposes. So again, the policy lever comes. So if you are going to make an application, first of all, you have to establish that it must be invention, not discovery. Second, you have to look into the section 3, whether it is allowed or permitted in that very list or not. So once it is established that it has passed the test of, invention, and also it is being allowed under the patentable subject matter in the respective law, then you need to establish its novelty. So what is novelty? Novelty means it must be new. How can you assess whether it is new or not? So you have to look into the prior art. Prior art means the related technology or technological field. You will explore, you will search prior art searches through which you will ascertain whether the same invention or the features of that very inventions are already being given patent or not. So novelty is a criteria which is not that much difficult, because if you are able to prove that some of the features in your inventions are altogether different from the existing invention or existing patentable invention, then you can easily pass that test, because one feature is enough to establish your novelty. But non-obviousness is a little bit complex criteria to establish. Non-obviousness, as the term itself suggests, that it is defined, I mean, in certain way in different countries. So in India it has been defined like any invention which is in question must make a technical advancement, or it has an economic significance, and along with that it must not be obvious to a person skilled in the art. So person skilled in the art is that very person of ordinary prudence who is working in the concerned field of art. So if you are, for example, if you are claiming an invention in mechanical field, a specific mechanical field, then you have to look into the prior arts available in that very field, and you have to establish that combining two prior arts, whether that person can easily figure out that what you have invented. If it is a very obvious result and it could be anticipated by anyone who is working in that very field, then it will not be given way for the patenting, and it will be objected on the ground of non-obviousness. So what you have to establish is that what you have invented is beyond the imagination of those people who are working in that very field, and they cannot figure out that this is the thing which you have invented. So person skilled in the art is the parameter through which the obviousness is being tested. Then if you pass that very test and it was found inventive, that it has not been anticipated by anyone or could not be inferred in that way, then you proceed further to establish the utility of your invention. Utility is otherwise defined here in India as industrial applicability, as well as if you refer to TRIPS, it is also defining this criteria as industrial applicability. So the point is that patent office grant patents for certain objectives, certain purposes. So if your invention is of no use, then there is no point of granting a patent. So you have to establish that it must have a utility. What would be the standard of utility? It is always changing. It depends how you define it. So in India, the criteria is termed as industrial applicability, means if you can make or produce, make or use any invention then in industry, then it could be considered industrially applicable, meaning thereby repetitively it must be produced in the industry, so it has an industrial color or industrial applicability. So for example, sometimes we talk about jugaad, which is a temporary fixation of certain problem, but it never gives a guarantee that that very trick which you have used may always be workable. So here on the count of utility on industrial applicability, it falls short because there is no guarantee of repetitive production, and unless and until you make your product repetitive, it could not be considered industrial. So industries are for manufacturing certain goods again and again, and on that count you have to establish that it could be easily produced or made or used in industry. So you have to provide certain indications regarding that by prototypes and all that, so that your utility may be figured out practically. Fourth criteria is a statutory requirement, which is very much in the nature of the patents. So as I said, that patent on one hand reward the inventor, and on the other hand it asks for the full disclosure of your invention. So it is also termed as a quid pro quo for granting patents. So if the state is granting you a patent, it asks certain in lieu of that. And what it asks? It asks that you must disclose your patents so that the other potential inventors can learn from that, and they can also improve upon that, and they can also claim for patents. They can also come up with new technological solutions. So this written description or full disclosure is enabling the potential inventors to invent more, to make further improvements. And as we all know that patent is not only granted for the radical invention only, it is also granted for the substantial improvements. So if the existing invention is there and you put something very substantial in it, then that is also worthy of being protected under patents. So that was about the patents, how you can get it, what are the criterias. Now briefly I will discuss what are the rights of patent owner. So in any case, in case of any property, there are a bundle of rights which are given to the property holder. Likewise, in the IP regime also, the bundle of rights are being given to different IP holders. Though these rights vary from one set of rights to another. When you talk about patent, it may be something distinct. When you talk about copyright, it might be different a little bit. So what kind of rights you get, you have to be sure about that. So patent owner has a right to decide who may or may not use the patented invention for the period during which it is protected. So the determination or the autonomy is always with the patent owner. Either he go for licensing, he go for certain other transactions or not. Patent owners may give permission to or license other parties to use their invention on mutually agreed terms. And owners may also sell their invention rights to someone else who then becomes the new owner of the patents. So as an owner, you have all the liberty that you can transact your patent, commercially exploit your patent in whatsoever manner you wish, because it is your property and you can do it in that way. Once a patent expires, protection ends and the invention enters into the public domain. So as I said that the patent term now is settled as 20 years. So after 20 years, it falls under the public domain and you remain with no exclusivity over the same. So on the one hand, patent system grants patent owner certain rights. On the other hand, it puts certain limits on the exercise of those rights. So that is why a balanced approach is embedded in the very concept of patents, but how it is exercised is a little different from what you study in the theory. Theoretically, it is all imbibed in the very concept of patent and it looks a very, very balanced system. But it all depends that how the patent offices, the interpreters interpret these limitations in those practices. That will define the pathway of patent and that will, confer or that will create a kind of balance between inventor and the public interest. So what are those limits to patent rights? So research exemptions are very, very important and they are there in patent laws, which allows researchers to use any patented invention for experimental purpose only, instructional purpose only. Again, there is another limit which is governmental use or compulsory licensing. If you are exercising your rights, patent rights, in a way which is not in tune with the policy of the patents, for example, if it is not complying with or conforming to the affordability in India, it is not conforming to the accessibility which must be ensured by the patent right holder, then it could be excused. And in certain emergent situations, government is all empowered to use it and even acquire it also, and after that it could compensate that very patent holder. So these are the various limits which put patents in shape and patent rights under control. So many times we think that patents are only for complex inventions and it is meant for very complex setting where heavy industries or complex industries must make an invention. It's not like that. It all needs to identify a technological problem first. Even around you can find a very, very a small, you can say, issue, though that issue may be very serious for the locals, but that may not have that much intensity. So even a small invention can change life of many people or make your life convenient. So it is an example of a frugal innovation where you may see here that how can you extract certain items from a jar, you can say jar, that is also a kind of invention which make the life easy. So it is termed as crazy kids invention turned into real products. So you need to identify what is problematic and how, whether there would be any technological solution to solve that very problem. So identification and then providing a solution, technological solution, is always giving rise to patentability. So if that is conforming all the criteria of patents, then your invention, which may be a very small invention, is all worthy of patents. The next example is a very advanced example where you can see the inventions may be very advanced, where we talk about real flying bike inventions. So what kind of invention and innovation process we need to adopt? So to me, we need to promote both the small inventions, the local needs. In one of the themes of WIPO, it has been the slogan of that very year, that innovation improving life. So innovation is nothing but how you apply your invention and make it workable in the real world. That very thing is termed as innovation. So there is a distinction between invention and innovation. Invention is an individual activity carried on by the inventor when he invents something. Once he invents something, he may file a patent over that, but how he bring that very invention in a workable form, that needs commercialization process, that needs various transactions through which the new items could be brought into the market. So innovation in a generic way means bringing something new to any field, may it be technological field, may it be any other field. For example, if I talk about the legal innovation, if new aspects of law are coming up, emerging up, and they are talking something very substantial, they are also adding to the jurisprudence which is already established. So that may be considered as a judicial innovation. Various decisions may be very progressive decisions which may be considered as a very innovative decision. So the thing is that only inventing is not the key. What is the key? That it must be backed by a supporting mechanism where the invention must be made workable. On this count, on this very brief note, I am just stopping it here. We'll resume again.